Hello and welcome to the Talking Law, the podcast where you can hear barristers, judges, solicitors, managing partners and more talk about their careers and lives in law. I'm Sally Penni MBE. I'm a barrister at Kenworthy's Chambers in Manchester. I'm also the founder of Women in the Law UK. This episode is kindly supported by the law group at Salford Business School, the home of the University of Salford Silks Pro Bono Law Clinic. I'm delighted to be talking with Lord Jonathan Sumption in this interview. Lord Sumption is a former senior judge who sat on the Supreme Court of England and Wales and acted as a barrister on many high-profile cases prior to this, many of which you will have heard of, including the Abramovich case. Lord Sumption is also a former academic, historian, and has authored several books. Hello and welcome to the Talking Law podcast. I'm absolutely thrilled to be interviewing Lord Sumption KC, or Lord Jonathan Sumption KC. Not KC. Or shall I get you to introduce yourself? Who are you?
Jonathan Sumption. I retired from the Supreme Court of the United Kingdom at the end of 2018. I think that's the only useful piece of information about me.
Well, I disagree, and I have a lot of questions to ask you on that. Thank you very much. Can we start from the beginning? You were a barrister at the bar, and then, of course, you were appointed to the Supreme Court. When you are what would be a law lord, they changed that title, of course. Subsequently, you became Lord Justices and so on. I still like the title Law Lord. But can we start from the beginning of your career? You went to Oxford, and you had quite an interesting career before you came to the bar, my understanding. Why did you decide to choose law or the practice of law?
Well, I started by being an academic historian. I was a fellow of Magdalen College, Oxford. I was primarily a research fellow, but I did also teach undergraduates. And having done that for 4 years, I decided to change career. I was then 27 or 26. And there were two reasons really. One was that I wanted more money. It was as crude as that.
Yes.
I didn't want an enormous amount of money. I just wanted enough to pay my grocery bills and have some good holidays. That's not a great ambition, but it wasn't one that I thought I was going to achieve on a Don's salary.
Yes.
The other reason was that at the age of, in my mid-20s, you inevitably look ahead at people who have done the same thing and are in their mid-40s.
Yes.
And you say, do I really want to be like that? Are they happy? And sometimes the answer to both questions is no. That's the other reason.
Yes. Now, you corrected me when I said not KC.
Mm-hmm. That's because QCs and KCs surrender their patents of appointment as Queen's Counsel on appointment to the High Court or above.
I see.
So that when you become a circuit judge, you keep your silk, but when you become a High Court judge or above, you don't.
Right.
So you cease to be Queen's Counsel or King's Counsel.
So fascinating, because of course you also received an honour, an OBE.
Yes, that was some years earlier.
Yes.
And it was nothing to do with law.
Yes. Well, I'm coming to that. I've written several books, nothing of the volume and the sheer breadth as you have. You know, your 4-volume The Wars books. And then, of course, you've written much more recent books as well. So you've done a lot with your career. How have you managed to have a successful legal career? I won't go through all your cases because we'll be here.
Please don't.
all day long. And people who listen to this podcast know there's a biog that is attached to it. So you can see all the cases listed there, including the Hatton Inquiry. There's a very famous case, the Abramovich case. Mm-hmm. There's so many cases that you've been involved in. Do you have a favourite or a meaningful case?
No, not really. I enjoyed the Abramovich and Berezovsky case. It was the last case that I did at the bar.
Yes.
It was a case involving no law at all. It was a swearing match between two people about what happened at a series of meetings when no witnesses were present and there were no documentation. So that's a challenge.
Yes, quite. Now, I asked you about the books, and I'll come back to the Abramovich case a bit later. But I asked about your books. How did that come about? Because
it was a continuation of my work as a Don.
Yes.
I taught undergraduates the history of the Middle Ages in both Britain and continental Europe. It was a subject that I hugely enjoyed, and I wanted to retain something of that when I went to the bar. So after faffing around with a number of other projects which came to nothing, I started writing about the 100 Years' War at the end of the 1970s. I was doing that for 43 years until I finished last year.
Wow. And I think the fifth book in that series?
The fifth and final volume is due to be published in the summer of 2023, so in a few months.
Oh, well, will there be a book launch? We'll have to try and muscle in our way in.
That really depends on my publishers. There might be.
Yes, well, we have a book club, you see, in Women in the Law. So we read books and we invite the authors to come and be grilled, so to speak. There's an audience and they ask questions. So even the secret barrister...
Sounds very intimidating.
It's not. It's largely a varied group who will probably say, I loved book 1, not sure about book 3, or why did you do this, or why did you do that? So it's actually quite fun, not that. So you must come on. Yeah. But the question of law, so you came to law to earn a living. My branch of the law is criminal law, public law, and employment law. How did you decide which areas to specialise in?
Well, I didn't really decide. Essentially, you have to find a chambers, and you can't be too choosy. At least you couldn't be too choosy in the 1970s when I was applying to chambers for a place.
Yes.
So you took whatever you could get. I had done pupilages in commercial chambers.
Yeah.
So that was commercial chambers were the obvious sort of chambers for me to apply to. But actually, it took me 2 years after the end of my pupillage to find a place to practice. So I was pretty desperate, and I wasn't going to turn down anything that was half respectable.
Yes.
As it was, I got something that was very respectable, a tenancy at Brick Court.
Oh, yes. Where you remained.
Where I remained.
Yes.
I mean, of course, in the 70s and early 80s, people did not change chambers for their entire career.
Yes.
Now it's perfectly routine. It's a big change that's come to the bar. But I never had any inclination to change chambers. Brick Court was a wonderful place to practice with a very varied diet of work.
Yes. So interesting. So now, to deal with the cases point, do you have a favourite case that you've done? Or
No, not really. I have a few cases that I wish I'd never done. The rest of them are roughly equal in my book. I did enjoy Berezovsky and Abramovich, although it's never a case that's going to go down in the law books because it had no law in it at all, really.
Now, we have some quite young or younger listeners from all sorts of backgrounds, and in fact, all across the world. This podcast is very popular in the Caribbean, for example. And so I wonder if you can just talk to us. I mean, you mentioned that case very briefly, but how was the advocacy in that case different to perhaps other types of advocacy?
Well, it was a case that turned entirely on cross-examination.
Yes.
I cross-examined Berezovsky for 9 days.
Wow.
And there were lots of other witnesses, but they were much shorter. None of them was really more than half a day.
Yeah.
And some of the burden of that was taken by my wonderful junior, Helen Davies. So it was an entirely fact-based case, which turned on cross-examination. There are lots of different types of advocacy. There's the appellate advocacy or advocacy on pure questions of law.
Yes.
There's cross-examination, and there's just the business of making submissions, analysing facts in the most persuasive way that you can manage. When I came to the bar, I had no idea whether I would be any good as an advocate. I had a vague idea that maybe it was better to just have an advisory practice because that might leave me more time to pursue other interests.
Yes.
But I quickly discovered that advocacy is actually where the magic is.
Yes.
I went on from there, really. Nobody starts out at the bar by being a good cross-examiner. It's something that you just have to grow into with a lot of practice. So the ideal is to have the kind of practice which, when you are a bit green and starting out, you're cross-examining people on sort of trivial motor cases.
Yes.
Where it's not a tremendous disaster if you don't do it very well. And sooner or later you graduate to cases where it really matters a great deal.
Wow. Well, I teach advocacy. I think you have to be approved now, for my circuit and indeed for the Inn, and some of that is international. And I always say preparation.
Yes.
That's my 3 top tips.
I mean, the basic rule is you have got to know the material better than the witness. You've got to know it so completely that you're never going to be put off by a witness's answer. Some people prepare meticulously and map out every single question in writing.
Yes.
But you quickly learn that you can never stick to that plan.
Yeah.
You basically have to be adaptable according to the answers that you get.
Yes.
And that means that you've got to have in your head all the material available and know how to find it quickly. In a criminal case, unless it's fraud, they tend to be relatively light on documents. I mean, burglars don't leave a document trail. But in civil cases, the volume of documentation gets bigger and bigger every year.
Yeah.
The fax machine and computerization generally has multiplied the weight of documentation, probably in every class of case, but especially in commercial cases.
Yeah.
When you think that in Abramovich and Berezovsky there were something like 60 files of documents, although not a single one of the relevant meetings was actually documented, you can see what the problem is. But you've really got to know what's in all of those documents.
Yes. Especially if you've got a stickler of a judge asking you.
Yes, but it's the stickler of the witness that's the real problem.
Yes.
Of course it helps to have a good junior with a capacious memory who can remember things that you have forgotten and put them in front of you.
Yes, but only when you're a KC. I'm a senior junior, if you like. If you're not blessed with a junior, you've got to do it all yourself.
Well, that's true.
Yes.
And people take silk younger in the commercial field.
Yes, they do. They do.
In
Younger.
specialised fields generally.
Yes.
It's simply because there is less leading work at the criminal bar, especially now with the CPS and the legal aid authorities being particularly stingy about representation.
Yes, absolutely. Lord Sumption, I wanted to ask you about your judicial career, because it's said that you are the only judge, probably because of your big brain, who was appointed straight from never being a full-time judge to the Supreme Court. Is that right?
Not quite. First of all, there have been, I think, 5 other people promoted directly from the bar since the Judicature Acts of the 1870s. I think that the last one before me was in 1948.
Oh, right. That's why no one remembers.
All right. Well, I remembered. I was born in 1948, so it's not a question of remembering.
Yes.
But that's the history.
Yeah.
The other thing is, although I'd never had a full-time judicial appointment before, I had a portfolio of part-time appointments. I sat as an appellate judge in the Channel Islands for a couple of weeks a year, and I sat as a Deputy High Court Judge and as a recorder of the Crown Court.
Yes. So why didn't you take the appointment or apply sooner?
Well, I was offered appointment to the bench in the days when it was done by a tap on the shoulder.
Yes.
More than once. And I decided to refuse, basically because I felt that when you're at the top of your game as a barrister,
Yeah.
of course it's a slightly dismaying prospect, becoming a full-time first instance judge. Suddenly you move from having the pick of the cases to having the dross. As a junior judge, you take what you're given by the listing office, and some of it will be interesting, some of it not so interesting.
Yes.
And I just felt that it would be a much less interesting job than the one I already had. I was tempted, because I think there are important considerations of public obligation. It's not just all about me.
Yes.
And so I was strongly tempted, but on balance I decided not to do it. I never expected the opportunity to arise to go straight to the Supreme Court. That is one of the most interesting jobs in the common law world.
Absolutely.
And I can't imagine that anyone would turn it down.
Yes.
I'm not suggesting that it was offered to me on a plate, but it became clear that I might get it.
Yes. Well, let's just talk about that for a moment. When you were sitting in the Supreme Court, of course, the makeup of the court was quite interesting, because at one point, before you retired, you had 3 women. And, of course, when you...
I think it was 2, in fact, because I think Mary Arden joined the court before I left, that's quite right, yes.
Yes. So
Just,
yes. And Baroness Hale was still president.
Yes.
Then. So that, of course, now...
And there was Jill Black.
Yes, there was Jill Black. She'd retired. There's only Dame Vivian Rose.
Yes.
So there's only one woman now.
Yes.
Left. And so I am, as a woman, concerned about representation in the highest court, in that very court. And you have said in the past that it would take 50 years to gain some sort of equality.
Well, that's a different issue, and I'll come to that. But I think that there are important issues, which we'll no doubt get on to discussing, about representation of women and ethnic minorities in particular,
yes,
in the judiciary at large. But the position of the top court is actually rather special, because the qualities required are exceptional, and there are you're not spoilt for choice when you're looking for candidates for that job. And not perhaps spoilt for choice is an unduly patronising expression. You're probably not spoilt for choice at any level.
Well, you might.
But the sort of people that you want in the top appellate court have to have certain qualities that are not very common. One of which, for example, is that at a time when specialisation is increasingly the theme at the bar and among the solicitors, you need people who have the ability to look over the fence into the garden next door. People who are rigidly focused, as a very high proportion of barristers are, on their own speciality, are much less likely to be able to look at the way that the law develops as a whole, something which requires you not necessarily to be a master of every legal subject, but to have a reasonable acquaintance with the principles underlying every area of law. And that, together with the intellectual requirements, these people are not actually that easy to find. Now, obviously, you need, in order to maximise your chance of finding them, you need the broadest possible range from which to choose, including women, ethnic minorities, and indeed members of the bar. But it's still not an easy job.
No.
So I think one should be very careful about taking 12 people, quite a small number, and counting the number of women or members of ethnic minorities in that 12 and treating that as an indication of the success or failure of diversity in judicial selections. You can carry that exercise out meaningfully when you look at the judiciary as a whole, because after all, the High Court and the Court of Appeal combined, we're looking at between 180 and 200 people. And when you look quite in circuit judges, one's looking at more than 1,000, I think.
That's about right.
looking at the proportion that this category bears to the whole is a rather more meaningful exercise when you've got a group of that size than it is when you're just looking at 12 members of the Supreme Court.
Yes, and it is, and it's an important point you make. But just to follow through, though, Lord Reid, the current president, of course, gave a speech where he was saying he would like to see some, I suppose, ethnic diversity in the Supreme Court before his retirement.
Oh, that'll happen.
Do you think it will? Because in the Court of Appeal there is still no full-time, essentially black sitting full-time judges.
Well, if you're distinguishing between black judges and other coloured judges...
Yeah, well, and other minorities, of course, there are, yes.
But I think one should be careful not to subdivide the field in too much detail.
Yeah.
Because essentially what we are looking for is some signs that the judicial appointment process works well. Mm-hmm. And it seems to me that's at least partly a matter of attitude as well as availability of talent.
Yes.
And I think that you can gauge the attitude of the appointers from their willingness to appoint people from non-mainstream sources, whether they are of Caribbean or of African or of Indian or Pakistani or Sikh origin.
Yes.
The position at the moment is not good at Court of... Well, it's not good at the High Court level generally.
Yes.
And even less good at Court of Appeal and Supreme Court level. But, that will change. I think you have to bear in mind that the period of time which most people spend before taking up a full-time appointment is between 25 and 30 years.
Yes.
And so that is the time gap between a major change to the entry into the profession,
yes,
and a significant change to entry into the judiciary.
Yeah.
That's not the whole explanation of the problem. It's only part of it, but it is part of it.
Yes. Now, can I ask you about prorogation, the prorogation case? Mrs. Miller, and I've interviewed two people, well, three actually, from that case. It was quite an interesting case.
Oh, yes.
It's one of the few times that even in the robing room, everybody was crowded around Mac laptops watching on so many different levels in terms of the advocacy, the law, and so on. So I've interviewed Mrs. Miller, David, Panic, and Lady Hale. Now I'm interviewing you, and I just wondered...
I didn't sit on the prorogation case.
No.
I sat on the first one. I'd retired before the prorogation case.
Yes, so what I wanted to ask you, actually, having not sat on it, have you got any views about it?
Well, yes, and I've expressed them publicly. Initially, I thought that the attempt to challenge the prorogation was likely to fail. I thought that the prorogation was an appalling decision on the part of the Prime Minister and a gross breach of constitutional convention.
Yes.
But the thing about constitutional conventions is that most of them are not judicially enforceable. They're political conventions. The price you pay for ignoring them is a loss of political support rather than having your decision quashed by the courts. I changed my mind about that in the course of the case.
Yes.
Not in the course of the argument, but rather before that, because it seems to me that the problem about the prorogation was that it converted a public power into something more like a private privilege of the Prime Minister.
Yes.
Because if the Prime Minister had won that case, he would have been responsible to absolutely nobody, not to the Queen, because the convention is that the Queen's powers are exercised by ministers. i.e. by himself.
Yes.
Not to Parliament, because it would have been prorogued. Not to the electorate at large, because between elections the electorate has absolutely no way of bringing pressure to bear on the Prime Minister. So he would have been responsible to nobody. And it seems to me to be that one important principle of public law is that you cannot simply have a void of authority in which somebody has a public power for whose exercise they are not responsible to anybody at all, not even to the courts,
yes.
If he'd succeeded in his submission that this was non-justiciable. So I changed my view. Now that's not precisely the ground that the court gave, but the reason for that is that the government conducted the case with the utmost incompetence possible. Now, that was not the fault of their representatives in court. I believe it's right that they were given the right advice as to what they should do,
yes.
and ignored it.
Yes.
What they should have done was they should have said, look, there's no doubt that we, the government, have the constitutional function of conducting foreign policy and negotiating with the European Union. In our judgment, it is completely impossible to do that in the national interest if we've got all this noise in the background coming from the House of Commons.
Yes.
We have therefore got to have a period of radio silence while we sort this, and then Parliament can come back and pass judgment on what we've done. Now, that might or might not have been right, but it would have been a purely political question. I think it would have been extremely difficult if they'd said that for the courts to second guess them.
Yes.
Because what they actually decided was that you couldn't prorogue without reasonable cause. But what is a reasonable cause, and who is to be the judge of what causes are reasonable when the judgment that is being made is 100% political? Your judgment of the negotiating situation with the EU and of the political position in Parliament.
Yes.
I can't see how the Supreme Court could possibly have resolved that. But the government didn't take that line. They didn't take that line because Boris Johnson had sent out a circular letter to all MPs explaining the prorogation, saying this has got absolutely nothing to do with negotiations with the EU. It's all a matter of practical time management. Now, that was complete cobblers.
Yes.
But having said that, he didn't want then to say, well, actually, that was a load of baloney. The true reason was that we basically thought we couldn't negotiate a reasonable deal with Parliament jumping up and down in the background. Now, the result was they put in no evidence at all. They didn't even have the traditional civil servant's affidavit or witness statement saying these are the reasons. So that, in a sense, it was very much easier to wrong-foot them.
Yeah.
The Supreme Court simply said, you need reasonable grounds. We don't have to decide what reasonable grounds are because they haven't put forward any at all. Now, that was a really serious tactical mistake. I suspect they would still have lost, but I think they would have lost for the reason I thought that they should lose, and not for the one they gave.
I really rather like that. But just before we move on, I wanted to ask you about the gender issue, which we were going to come back to, and this idea about achieving gender equality taking 50 years. Why do you pit it at 50 years?
Well,
I'm just picturing, I think it was a headline in the Times when you said it. Give us a context and why you
you've got to remember that, first of all, this came from a lecture that I gave shortly after my appointment, and it reflected the experience that I had had sitting as a Judicial Appointments Commissioner for the first 6 years of the Commission's existence. Now, that may or may not still be the case today, but it reflected very much the difficulty that we had had in devising policies that were likely to lead to a bigger representation, particularly by women and by ethnic minorities, without departing from our statutory remit, which was to make appointments exclusively on merit.
On merit, yes.
And the problem about merit is there's an argument that that appointment of minorities is an appointment on merit because the judiciary needs a more balanced representation of different sectors of the population. But it's pretty clear that the way that the Act is framed is treating merit as the quality of individuals rather than the quality of the judiciary as a whole.
Yes.
So we basically had to square that particular circle, and it proved very difficult to do. Now, diversity in judicial appointments is a very difficult subject.
Yes, it's one of my questions.
And the basic problem is different depending on which sector you're looking at. In the case of women, it certainly was the case, and I should make it clear, I haven't actually looked at the data for the last 3 years, so this is a moving situation.
Yes, it is.
But in the case of women, I always felt that the biggest problem was the very high dropout rate. Women have been slightly more than half the recruitment to solicitors since the early 1980s,
Yes.
and about half for a slightly less long period, but for a considerable number of years at the bar.
Yes.
There is a very high dropout rate reflected in the fact that the proportion of juniors who are women is much greater than the proportion of silks who are women.
Yes.
And the intensity of work, the difficulty of combining work at that level of intensity with just about anything else is clearly part of this.
Yes.
This is actually a very profound societal change, and we are in the middle of it. I think one of the biggest factors militating in favour of change is likely to be the sharing of household work and childcare between husband and wife.
Yes.
Now that's happening. My children's way of looking at this is completely different from my own, and even more different from my parents and grandparents.
Are you going to be on the school run?
Well,
or have you been?
The fact is I didn't, but my children do.
Yes, yes.
With their children. And this is a very fundamental change in our social habits. And a lot of the problems that we have about diversity, not just in the judiciary but elsewhere,
Yes.
are actually down to very profound societal habits and ways of thinking, and in part to the educational system. Now, in the long run, I have absolutely no doubt that this will change, but it's extremely difficult to grapple with a problem like that when most of the variables are not within the control of the selecting authorities.
Yeah.
It's too late for them to do anything about the educational system.
Yeah.
It's too late, well, it's never going to be possible for them to do much to change the habits of the society around them, but they will change spontaneously in any event. And, things are undoubtedly a lot better now, 12 years after I left the Judicial Appointments Commission, than they were then.
Yes.
Now, the problem about women is, I think, closer to being resolved than the problem about ethnic minorities.
Yes, it is.
Because the dropout rate, there is a dropout rate, but it's not due to the same factors, and it's not such a big factor. The dropout rate is smaller in the case of ethnic minorities than it is in the case of women.
Yes, it is.
Or at least that was the position when I last looked at the figures. I don't know what the reason for that is. I have heard a variety of explanations, none of which strike me as wholly convincing, and it was a problem that we discussed endlessly on the JAC when I was a member.
Yes.
My instinct is that the problem is basically one of educational disadvantage for some ethnic minorities at any rate, which starts at a fairly early stage and has a knock-on effect on people at a significant stage of their career when they're contemplating at university and so on. I don't pretend to have the answer, but I do recognise that there's a problem.
Yes.
As to the 50 years, obviously that wasn't intended as a precise estimate. But
I hope not.
But you have to remember, first of all, that any change that begins at the bottom and changes in patterns of household chores and childcare sharing and so on do start at the lower of the age spectrum.
Yes.
Any change of that sort is going to take at least 20 years to feed through to judicial appointments, because that's the period of time between entering the profession and being considered for judicial appointments, at least 20 years, usually 30.
Yes.
So, right, you've got half your 50 years there. The rest depends on how fast you think that these very fundamental changes in educational patterns and in societal change and in the way that families organise themselves are going to take. I don't think you can be precise, and I wasn't intending to be precise in saying 50 years, but I could see it taking a long time.
Yeah.
I did enter one caveat, which was that I thought that one thing that would accelerate the change was a positive discrimination. But positive discrimination was and remains unlawful.
Yes.
It wasn't permitted by the statute from which the JAC derived its powers. It would probably have happened if the Lord Chancellor had retained his powers of appointment, because
Yes.
he would have been able to do many things which he didn't need to explain in too much detail. It's quite a delicate issue.
Yes.
And our hands at the JAC were tied.
Well, what do you think about this then? Because the JAC appointment system has got to be better, certainly for my generation, than the previous appointment of, the perception of just appointing your friends.
Well, I don't think that was actually ever really the
No,
case.
but that's the perception that,
Yes,
but
I mean, there's no doubt in my mind that not least because of the pressure that the JAC came under from successive Lord Chancellors
Yes.
to produce more striking diversity figures, we were constrained by the terms of our appointment and of the statute.
Yes.
The Lord Chancellor would not have been so constrained. And so I've absolutely no doubt that that diversity would have improved faster if the Lord Chancellor had retained his powers of appointment. There would have been lots of other objections to that, such as the ones that you've mentioned.
Yes.
The perception of cronyism, though I believe that was never the reality.
No.
I agree with you that it was the perception.
Yeah.
And the sheer opacity of the system would have invited all kinds of criticisms, some of which would no doubt have been unjustified, but who would ever know with such an opaque and complicated system.
Yes. Yes.
So, I think that there were advantages, certainly as regards diversity in the old system, but it was absolutely right to change that.
Yes, it was.
For all the reasons that I think everybody's now agreed on.
Yes, quite. Now, I want to ask you about people who know you who are not in law, people who are not at the bar like I am, because you've got a bit of a fan base or fan following, and are recognisable from Radio 4 to Newsnight during the awful COVID-19 pandemic, because you opposed the lockdown rules, and you spoke about it publicly. I don't think you were afraid. So the first question was about, once retired, did you feel a sense of freedom to speak about what you like, which you, of course, wouldn't have had before as a full-time salary judge? And secondly, what do you think about the lockdown rules, really? Because the fallout and the consequences of all of that is still going on, in my view.
Yes. Well, to take your first question first.
Yes.
A retired judge is obviously freer to speak his mind than a serving one, but he's not totally free, because there is a convention, maybe putting it too strongly, but there is an understanding, which I think is wise, that judges should not, even in retirement, become too controversial on politically electric issues. And that was a principle which I comprehensively broke during the lockdown.
Why did you break?
And it was a principle which I recognised as being important and which I would normally have adhered to. There are, however, some issues which it seems to me are so fundamental that you have to stand up and be counted.
Yes.
I thought that this was fundamental because it was an exercise of authoritarian government, which it seemed to me was likely to influence the ways that governments behaved on a variety of other issues once
Yes.
they got away with it once. And it seemed to me that the implications for the future of government in this country were potentially extremely serious. Now, obviously that tied into my particular views upon the lockdown generally. I got into this, in a sense, accidentally. The World at One asked me to comment on the first lockdown very shortly after it had been ordered.
Yes.
And I said that I recognised that that COVID was a serious matter. I certainly wasn't belittling it at all.
No.
But I thought that there had been no thought given to the collateral consequences. As the pandemic unfolded, I had two broad objections to it. One was that it seemed to me that with a pathogen that caused serious illness, it could strike anyone, but it actually caused serious illness or death,
Yes.
only in identifiable categories of people, essentially the old and people of whatever age who suffered from one of about 15 identifiable, mainly respiratory issues.
Yes.
And it seemed to me extraordinary that the government did not use this fact as part of its policy. There was absolutely no reason why people in categories that had limited or no vulnerability to COVID shouldn't have been allowed to get on with their lives in the ordinary way.
Yes.
They would have acquired a substantial level of immunity. It wouldn't have come anywhere close to herd immunity, but they would have acquired some immunity. We wouldn't have suffered the catastrophic collateral consequences that we did. And we could have protected the old and the vulnerable in other ways by encouraging them to take sensible precautions, the kind of precautions that were imposed on everybody, whether they needed them or not.
Yes.
That was one reason, and the other was the sheer scale of the collateral consequences. It became very quickly completely clear from talking to ministers and to other people involved in the decision, as I regularly did,
Yes.
that, and as is now known, that the government never carried out a serious cost-benefit analysis. They never carried out the kind of analyses of the collateral consequences that would follow for health, mental health, ischemic heart disease, cancer diagnosis, and so on.
Yes.
They certainly never considered the sheer scale of the economic and educational implications of this, which it's becoming increasingly clear since the pandemic have been catastrophic.
Absolutely.
And will continue to be really profoundly damaging. And I thought that this was a gross failure of government, and it sprang largely from their desire to shield themselves from criticism by hiding behind the scientists. Although the decision was never a scientific decision alone, it was a political decision which depended on weighing up a lot of economic, social, educational, clinical and other factors, and arriving at a decision which produced the least bad result, bearing in mind there was never a perfect result, never a wholly good one.
Yes.
So it seemed to me that the combination of a highly authoritarian style of government, largely sustained by sowing an unnecessary degree of fear and panic in the public, the collateral consequences and the uselessness from a health point of view of much that was done, was a pretty comprehensive indictment of government. So, faced with the choice of saying that, or keeping my mouth shut as an ex-judge, I decided that it would be a better service to the public to say the kind of things that were manifestly true, but which nobody else was prepared to put their heads above the parapet and say. One advantage of being a retired judge is that the judiciary has a high degree of respect in this country.
Yes.
And you can say things that, if said by others, would lead to a volley load of ordure and abuse. Actually, I never got that. At the height of it, I was receiving 100-odd letters a week.
Yes.
And that's not a particularly scientific guide, because obviously people who think that you are a twerp and completely wrong are much less likely to write a letter to say so than those who admire what you're doing. Even so, you would expect more abuse than I actually got.
Yes.
I got a fair number of letters which said, I don't agree with you for the following reasons, i.e. reasoned, sensible letters written by people who had thought their position out.
Yes.
And I always answered those.
Did you?
Yes, of course. I mean, if they'd been, several dozen a week, I probably wouldn't have been able to.
Yeah.
But, I got 3 or 4 letters like that a week.
Wow.
And I would write and answer them. And people made serious points, and sometimes you said, I disagree for this reason. And sometimes I said, well, I think you've got a perfectly good point there, but I think it's outweighed by other factors.
Yeah.
Public policy is never clear-cut.
Yes.
It's always a question of pluses and minuses.
Yes.
And you can believe in both.
Do you think there's been any learnings, though, from looking at the regulations? Because a lot of my time in lockdown was spent advising people who may be affected or not, employers and so on, and looking the actual regulations. And I had quite a long conversation with Adam Wagner, who's written a book about the...
Yes, I've read it.
Yes, so, and I had same conversation with him, that, have there actually been learning? Shouldn't there be sort of draft or watered down drafts of kind of public health regulations in case? Because, I've taken note that influenza is on the increase in turkeys. Just before Christmas, there was a whole load of stuff going on.
It has been on the increase here. That's now going down.
Exactly. But I just wonder if climate change and whatever else, and there's various factors are going on, means that there's more likely to be other viruses of this nature. Shouldn't there be a working group, perhaps there is, of how to deal with it?
Well, there are a number of issues there. One of them was, of course, the drafting of the regulations, which was very unsatisfactory.
Yeah.
They were extremely complicated. They were rather arbitrary. And
they had been amended every time.
Then they were amended at very frequent intervals, so it was extremely difficult to keep up with them.
Yes.
And the sort of amendment that says, in the 5th subsection of section 142, delete the word "and." So you have to. It takes ages to work out what the current law is.
Yes.
That's extremely unsatisfactory. It was made worse by the government's habit of giving so-called guidance, which always went a long way beyond the regulations themselves.
Yes.
So that's one lesson. I don't know whether that will be learnt. I mean, people have been complaining about the drafting of legislative instruments for donkey's years, and they don't seem to have got very far. If anything, I think that drafting standards of legislation are getting worse.
Probably because it's you and I drafting them.
Well, that's always a temptation to say that.
I know. I can only say that to you, but...
I mean, the other question, I think the big question, is, are we likely to have another lockdown? I mean, I think you're right to say that at an age of increasing movement of both goods and people and animals,
yes,
we must expect pathogens to spread around the world much quicker, and zoomorphic illnesses, spread from animals to people. Are
like swine flu, that's how.
Well, they're a growing risk, not only in China.
Yes.
So we must expect more of this. I think 2 things. First of all, I think that I'm not sure about a working group, but clearly we need people to draw contingency plans. Now, that did actually happen. After SARS-1, at the beginning of the current century, all of Europe, including the UK, in fact the UK was in the vanguard, started developing contingency plans to deal with this kind of problem. It was number one, the risk on the National Risk Register from the moment it was published in 2008. There were working groups preparing plans. The plans were updated, not regularly enough, but they were updated. The problem was that when the pandemic broke out, these plans were all binned. The plans had not envisaged lockdowns. Indeed, in the UK and indeed in Germany and other countries too, they were based on 2 basic propositions. One was that it was wrong to have one-size-fits-all measures. You should you should concentrate measures on vulnerable categories the moment that you've been able to identify them. It wasn't very difficult in the case of COVID.
Yeah.
And the other was you should avoid coercion and treat the public like grown-ups.
Yes.
Now, both of those principles, which I think were basically sound, had been the result of considerable thought over a number of more than 15 years.
Wow.
And I think they were entitled to a great deal more respect than they received at the hands of government in the blind panic that occurred in March 2020.
Yes.
In fact, our pandemic plans, which were more detailed than most countries, were very similar to those of other countries. In February 2020, the European Centre for Disease Control, which was an EU institution set up after SARS-1,
Yes.
Published the pandemic plans of all 28 participating countries. None of them, and I've been through all of them, suggested a lockdown, and some of them firmly rejected a lockdown.
Wow.
And this was an international mood of panic and copy my neighbour,
Yes.
which got out of control. It's terribly difficult for people who have taken measures that have completely mucked up an entire economy and large millions of people's lives to say, oops, awfully sorry, we made a mistake.
Yes.
So it's not, although that would be refreshingly honest, and in one or two countries has happened, I think that it is unrealistic to expect human beings to behave like that.
Yeah.
But we are much more conscious now that human beings are complex organisms. Human society is a complex organism. You can't muck around with some of the central features of human behaviour,
Yes.
like behaving as a social animal, without inviting unexpected consequences as well as expected ones.
Yeah.
I think the scale of the economic and social damage done will actually deter them from doing it again, except possibly in the case of a really catastrophic pathogen, something that generated 50% case mortality or something like that.
Like that, yes.
So I doubt whether it'll happen. But I could be wrong about that. Remember, I didn't think it would happen first time round.
No.
I was wrong that.
Well, I know the COVID inquiry is going on, and so led by Heather Hallett.
Yes.
And so I'm very interested to see where that will lead if it ever finishes.
I am very sceptical about that. I mean, terms of reference are very wide, but there's a very strong temptation to fudge things and to say and to avoid criticising people. I think they should be criticised, not for being wrong, but for making insufficient efforts to be right.
Yes, that's very interesting, actually. Oh, well, we'll have to revisit it. Can I ask you something about your interests and well-being? We're sitting in a wonderful library or office with more books than in my parents' library or indeed in my own house, and you're obviously very well read and have a large brain. I also noticed...
If you say so.
I noticed when you said earlier about your portfolio career that you have some other outside interests outside of the bar, including being a director at the ENO, the
Yes.
English National Opera,
And I'm a trustee
the
of the Royal
Academy of Music. Yes. So as well as writing, as well as Wreath lectures, and I wanted to ask you this question about well-being, and we have to be truthful. The life at the bar is tough, and we often burn out. It's half term next week. I'm going away with my children and my husband, but actually I know there's going to be a few days that I'll have to work, and we won't be able to finish the 2,000 puzzles. So how have you managed your well-being in your career at the bar and then also on the bench, and have those outside interests, like me with an interest in theatre, have they kept you balanced?
To some extent, I'm sure they have. I think that having two consuming interests, one of them professional and the other private,
yes,
is you're likely to be better at both of them than you would if you did one of them alone.
Yes.
How does one do it? Well, the answer is, some people repair old cars, some people engage in Morris dancing or bell ringing. This is my equivalent.
Yes.
I write history books.
Yes.
It's a leftover from an earlier career. I enjoy doing it. And I think that it's mentally refreshing not to be completely intellectually dependent on your job for stimulation. And the threat of burnout is much more serious if you are a monomaniac and you're only looking at your professional activities.
I totally agree with you as somebody who also has interests like yours. And what about the Reef Lectures? How did they come about? I really enjoyed them quite a while. 2019, I think. Mm-hmm. You gave them on BBC Radio 4 and they're recorded in front of an audience. I think my interest is probably biased because yours was delivered by somebody who knew about law and history than some of the others, I suppose. But how did that come about, and did you enjoy them? Because that led to your book, Politics in Decline, or had you written that book first?
No. That was the lectures, unadulterated, except in some. I incorporated in the published version points that had arisen from the question and answer sessions that followed every lecture.
Yes.
Some of which raised interesting points that I either hadn't been able to include because there's 28-minute lectures, yes. Or else hadn't occurred to me. So, further reflection always makes these things a little longer.
Yes.
How did it come about? Well, Gwyneth Williams at the time was the controller of Radio 4, and the appointment of the Reef Lectures is very much in her gift. They are probably the most prestigious public lectures that are given in the UK.
Yes.
I had these thoughts buzzing round my head for a number of years, and I wanted an occasion for expressing them, and the Reef Lectures was obviously the ideal opportunity. So basically I wrote to Gwyneth, who I didn't know, and made this suggestion, and she expressed enough interest to make it worth preparing a kind of summary prospectus,
yes.
which I sent her. We had a long conversation, and that was it.
Well, they were very good and very, very interesting. Now, this is going to be a very difficult question for you, because I think there's about 2,000 books in here.
What's coming now?
But two questions really, if you like. But do you have a favourite book? Not one of your own.
It wouldn't be one of my own anyway.
Well, no, I didn't think so. But often when I speak in schools, in primary schools, they say, because there's usually a banner with some of my books on there, about 16 books, and they say, which is your favourite book? And some of my books are children's books.
Right.
And so I might pick one of those just and then read a bit or something. But of my own, do you have a book, needn't be related to law, that's been quite a powerful influence in your life, or has inspired you in some way?
Well, actually, I think if I were to name a single book, it would be a book with which I disagree at the most fundamental level. I'll tell you why it's nevertheless a favourite book.
Yes.
I mean, one reads so many books in one's lifetime that appointing a single favourite.
I know. Well, okay, I'll let you have three.
No,
okay.
No, I'm not going to. That makes things 3 times more difficult.
I know.
But I would choose Hobbes' Leviathan. Thomas Hobbes was a 17th century political theorist who was an apologist for authoritarian, indeed absolute, government. I disagree completely as it's possible to disagree with his political ideas. But the great thing about Hobbes is that he was one of the greatest masters of the English language who ever wrote a book whose object was to persuade. And Leviathan is a book which patiently builds up his case in small steps, and each step seems totally convincing. And you eventually arrive at the conclusion. You say, well, blimey, however did I get here? This isn't where I want to be at all. And it's actually quite difficult to work out where you think he went wrong. Now, of course, one possibility is that I'm just being naive and he didn't go wrong. That's not a possibility that I accept. I think his diagnosis of human nature was too pessimistic. But basically, Hobbes is an object lesson in how to write persuasive and memorable English. For anybody who is thinking of being an advocate,
yes,
I can't imagine a better intellectual training than to read a book like that. And in a sense, the fact that I disagreed with it and that I think most people reading it today will also disagree with it, actually is good. It means that you have, it's as a piece of mind training, working out why it is that you disagree with something as persuasive as Hobbes is a really outstanding challenge. Everybody should try it.
Right, I'll remember that. That's your favourite book. Now, if you had to choose a legal character, a favourite legal character, it may be fiction. Who
Can I
would
choose
be?
a factual one?
Well, yes.
Okay.
And then I have a question about your life.
I've had contemporaries, or near contemporaries, at the bar who I enormously admired and who were formidable characters. They weren't just skillful operators,
yes,
though they were that too, but they were very remarkable people. So, if I'm required to choose a fictional one, well, that's easy, but the result is not going to correspond to anything you're ever going to meet in practice.
No, but you should. Well, why don't you name both of them?
Okay. Well, one is Sidney Kentridge.
Yes.
Who was the most mesmerising advocate that I ever had, either against me or leading me, or in the latter part of my career appearing before me as a judge. He appeared before me as a judge on his 90th birthday.
Yes, I've heard that. I think Panic may have mentioned it too.
Well, he was there. He was on the other side.
Yes.
And very unusually, but completely appropriately, he opened the proceedings by congratulating Sidney on being still in the full force of his powers at the age of 90, which he was.
Really?
So, he was a very remarkable figure, not just because he continued for so long, but because he had this astonishing voice, a remarkable intellect, an extraordinary memory, and was a very entertaining speaker.
Yes.
Humour has got its place in good advocacy.
Absolutely.
And he was a master of that.
Yes.
The other one, and I don't know that Sidney would be particularly pleased to have me mention him in the same breath, because they represented poles apart, was Gordon Pollock, who is now dead. Gordon Pollock dominated for many years the field of commercial law. He was a completely unconventional advocate. He was unbelievably fluent, and he was famously rude to everybody, including judges that he was appearing before. He got away with it because he was witty, and because he was extremely clever, and because people knew that. They made allowances for the fact that he was witty, and they realised that they needed to listen quite carefully to him because he was clever. But he was a tremendous character. Every convention that applies to the way that you need to behave in court was systematically broken by him almost every day of his life. Now, you can't help admiring that kind of chutzpah.
No.
And I also liked him very much personally. Not everybody did, because he took no prisoners.
Yes.
He's dead now, but he was possibly the most remarkable legal character that I encountered in 35 years as a practicing barrister.
Wow. And if there was a story being told about your career, both prior to the bar, let's not forget, and then at the bar, and then on the bench, and then your other work outside it, because really this podcast is about telling the stories about the leaders and the interesting characters in law. I have another podcast which is all about law, but it's not this one. But who would you like to play you? And of course, they don't have to look like you, as a colleague pointed out to me.
At the very thought of anybody playing.
Well, shall I make some suggestions?
Well, you're welcome to make some suggestions. Whether I'll agree with them or not, let's see.
I was going to say Colin Firth. When people ask me this question, I say it has to be somebody English because I'm English. But of course, there aren't that many good black English actors. Mm-hmm. So there has to be American ones. So I was thinking for you, maybe Colin Firth, or if it was an American, somebody
that would be the kind of solemnity.
Yes.
Which is how I picture myself. But of course, how one pictures oneself may be utterly different from the way that other people see you. So this is actually a very treacherous area.
Well, I can tell you that Lady Hale said Emma Thompson, because of course Emma Thompson did play that judge in The Family Case. Do you remember that film?
Wasn't that...
I can't think of it now. It's gone.
I don't think it was Emma Thompson. I think that it was... so when you say The Family Case, you mean...
It was called something like... not Family something. It's a book, and which was then turned into...
Who was the actress who played the Queen in the film called The Queen? It was
Helen Mirren.
I think it was her.
Oh, I'll need to check.
Do check. I probably got that wrong, but I think it was.
No, it doesn't matter. It wasn't part of this research, so I probably got that wrong too.
I suspect that if Brenda Hale chose her, it was probably for reasons not that dissimilar from my accepting your suggestion of Colin Firth. There's a certain solemnity and stature about Emma Thompson, and for that matter, Helen Mirren.
Yes.
Which would make her an attractive person to choose in answer to that question.
Yes. Well, we're coming to the end, really, of our time together, slowly. But one of the things I wanted to ask you was about young people entering the profession, the bar, whether it's at our end as barristers or solicitors, I suppose. But have you got any... You've given a lot already, but tips and guidance, maybe 3 top tips about how to cope in the profession. When I was recording this in the lockdown period, the advice often that I gave or suggested in response to my interviewing guests was different. It was often about resilience and not giving up, that type of thing. But I wonder, there are less pupilages on offer now. We're now in an economic downturn. This podcast doesn't age. That's what my producer keeps saying. It's sort of ageless. But if someone was coming to become a barrister now, in whatever jurisdiction, let's focus on England, what kind of top tip advice would you give them about, staying in the profession, entering, progressing?
The real problem is getting your foot on the ladder.
Yes.
And the big bottlenecks are pupilages and tenancies.
Yes.
I think you need to go to the best chambers you can, even if you think that they're less likely to be able to offer you a tenancy, because the best chambers are their pupils are likely to be more attractive catch for other chambers if you don't get into your first chambers.
Yeah.
If you've been trained by pupilages at a top set of chambers, even if you haven't got in, that's a big advantage when looking for somewhere else. But there's a huge element of luck in this, and it's terribly difficult to give people tips about how to maximise their luck. I have had an enormous amount of luck in the profession. Things could quite easily have worked out in a way which would have led to totally different results. I found myself in a wonderful set of chambers.
Yeah.
I discovered entirely by accident that there were things like cross-examination, which I turned out to be quite good at. And also just being in the right place when cases came along. For some years in the 1980s, I was regarded as the go-to person for contested takeover bids.
Yes, I saw that in my research. Why was that?
It happened completely by accident. I was sitting in chambers trying to complete an opinion about something completely different. When all of these takeover cases arise in an immense hurry at virtually no notice. When a solicitor rang up and wanted to speak to somebody reasonably senior, at that stage I was actually a junior silk, and he was put through to me, and so I was involved in the first big piece of litigation about takeover bids, which was a case called Datafin. Now that was pure luck. If I decided to go to the theatre that night, it wouldn't have happened.
Yes, yes, or not be in chambers, which is
yeah, of course.
Yeah.
So there's a lot of things like that, and you get returns from other people who turn out to be unable to do something, or you do a case which, when you took it over, seemed to be of no importance, but then turns out to be the leading case on an aspect of the law that you never realised was even relevant to it when you started doing it.
Yes, yeah.
So, all of these are parts of the chances of professional life. The bar is full of really talented people who haven't got anywhere because they didn't have the strokes of luck that other people had. And, it's awfully difficult to give people tips about that sort of thing.
Yes.
The only tip that I would give, which is a pretty hackneyed one, is take your holidays at unusual times. Being around in August is a great way to get the kind of work that would normally go to people who are much more senior.
Yes. Well, it's funny you should say that. Charles Barton, who used to be head of my chambers in Bristol, used to say that very same thing. He's passed away now. But but of course now with having families, you can't always...
well, that's of course a particular problem in current social world for women.
Yes. Absolutely. Now, the advice and tips you gave about yourself, really, was that you had an enormous amount of luck. But these sort of clever gurus and coaches would say that luck was preparation meeting opportunity. Do you kind of sign up to that?
Well, only partly. Obviously, you need to do that, but you can do it and get nowhere. And the difference is luck.
Yeah. Yeah, absolutely. Interesting, fascinating. So, Lord Sumption, what's next?
Well, I've just finished, after 43 years of writing about the 100 Years' War.
Yes.
I've just finished doing that.
Well, just give us a quick, because I've read the book, I don't want to ruin it, but can you give us a quick précis of what those books are about?
Well, they're about a classic series of wars in Western Europe in the 14th and 15th centuries, which is a fascinating period, partly because it is artistically a very beautiful period, partly because so much of the physical environment which it created, castles, walled cities, etc., actually still survives, partly because it is a period in which there's first really personal sources, memoirs, private letters and so on, begin to survive. But it was a series of wars, mainly between England and France. But the whole of Western Europe was involved. It's built out into Scotland, then an independent country, into what we now call Belgium or Holland, into Italy, into Spain and Portugal, into Germany and Switzerland. It involved the whole of Western Europe. And that is, it gives you a range of facts which are fascinating. It involves formidable linguistic challenges, which, I like languages.
Yes. Well, you speak 3, don't you?
I speak more than 3, if you allow me to include languages
please.
that I speak badly.
Yes, please
but,
do.
I can make myself understood in most Western European languages.
Wow.
And I speak French fluently.
Wow. And so I read in my research that you didn't learn that conventionally. You have a dictionary and you learn by listening to the to the people speaking.
Well, you just plough through a book.
Yeah.
Languages have a lot of structural similarities. Once you've grasped the basic grammatical structure of a language, the rest of it's vocabulary.
Yes.
And that just means means you need a reasonable memory and a dictionary.
Yeah, wonderful, wonderful. So after 43 years, the 5th book is coming out.
And I now contemplate a vast void in my life. I wish that I knew the answer to your question, what's next? I've got a number of possible projects, and I'm doing a lot of reading in order to refine them and decide which of them I want to do. But clearly, I'm 74, so I'm not going to embark on another 5-volume work.
No. And I suppose I should ask you about politics. And did you ever contemplate a career in politics?
I did, not for very long. And the reason I abandoned the thought pretty early was that I got married very young, and I was 21.
Yes.
And
wow, that is young.
I wanted to stay married, and I didn't think that a political career was the best way of ensuring that. The other thing about politics is, some professions, the bar, for example.
Yes.
If you get halfway up the greasy pole, it's half as interesting as being at the top.
Yeah.
Politics is desperately boring, except at the top. It's got a very narrow apex. And so, there are some people of supreme self-confidence, maybe the last Prime Minister, but one is an example, who don't worry about this. They're quite sure they'll get to the top. But most people can't be. And really, to flog through the backbenches and junior ministries in the hope of getting somewhere more interesting is a soul-destroying business. My father wanted desperately to be a politician.
Did he?
And it ruined his life.
Oh.
He never got into the House of Commons. He tried many times, unsuccessfully. And he felt this made him a complete failure. Actually, he was rather good at quite a lot of other things. But none of that counted for him.
Yes.
I didn't want to end up like that.
No. Well, what about the House of Lords?
Well, I don't sit in the House of Lords.
Well, I didn't think so, but did you have any desire or interest or anything like that?
I have mixed feelings about it. Lower Lords have not been members of the House of Lords since 2009, unless they already were before.
Well, yes.
The House of Lords is now a very demanding thing. You can't just wander in and out. You have to do it seriously or not at all.
Oh, right.
There was, at one stage, there was an understanding that Supreme Court judges would have peerages upon their retirement.
Yes, that was my understanding.
And Mrs. May decided to renege on that.
Okay.
She didn't like lawyers particularly and didn't relish the prospect of seeing more of them in the House of Lords.
Yes.
I would have had to apply, and my feeling was that, if I was a peer, I would want to do it properly.
Yes.
That would have involved surrendering a lot of other interests which I've got, musical, historical, and so on.
Yes.
And I had mixed feelings about that. So I did. Actually, I was encouraged to apply once, and I did, but it didn't get anywhere because I would have applied under the crossbench system.
Yes, yes.
And they only have, 1 or 2 vacancies a year, if that. So I wasn't at all surprised that other people were chosen. But I was in a way relieved because it gave me a chance to get on with things that are genuinely enjoyable.
Absolutely.
Whereas legislation, some of it's enjoyable, some of it isn't, but it's a much more mixed bag than the life I've got.
Yes, quite. And Lord Sumption, one of my guests on here was Leslie Thomas, Professor Leslie Thomas, now QC, and he has, he's black, and he has long dreadlocks. You may know him. And I asked him, is that a deliberate look? You could just have short hair or shave your hair, like my own brother is 6
Do
foot
I look
plus.
any different from the way you otherwise would?
Yeah, so I just wonder, your hair's quite long, and has that always been a deliberate look? Or?
No, it's the fact that my hair is cut by my wife, and always has been.
Good choice.
And I don't feel able to ask her to take time off to do my hair more than once or twice a year, so that inevitably, when one's coming up for another one, the hair gets quite long.
I love that. And then the Abramovich case, there were rumours about the pay that you were paid for it. I'm not asking
There
for that.
don't need to be rumours, because the facts are published. The taxation process meant that it was all over the papers.
Ah, right, okay. And so I saw that. So we started this interview with me asking you why you chose the law, stopped being a Don, and of course you're still a fellow at Magdalen.
No, I'm not still a fellow. I'm a member of the senior common room.
Oh, I see.
But that's different.
So I was just saying, on reflection, do you think you fulfil that? Earn a good living, have some outside interests,
Yes.
and had a happy life?
Well, I certainly had a happy life. As to whether I've fulfilled my idea of having more money, well, obviously, yes, I have. But, in a way, the bar is a bit like a one-armed bandit machine.
Yeah.
You pull the lever and nothing comes out, and then quite suddenly the whole of the floor is covered in silver. And you don't actually have much control over which it is.
No. Well, as I said to David Panic, you're very modestly dressed and a nice jumper. I don't see any gold medallions going on. So I don't know where the supposed millions have gone. But it's been very nice to meet you properly and talk law with you about your career at the bar and beyond. Thank you so much.
Not at all.
Thank you to Lord Sumption for telling me about his career and life in law. Thanks again to the law group at Salford Business School for supporting this episode. Do visit www.salford.ac.uk to learn more about the law group and their Silks Pro Bono Law Clinic. I also wanted to remind you and let you know about the Women in the Law UK annual Empowering You conference, which will be held on the 17th of November at DLA Piper in Manchester. You can book tickets through the Women in the Law UK website. Additionally, the Women in the Law UK annual dinner 2024 is now available. You can book tickets on the Women in the Law UK website with a guest speaker attending in Baroness Hale. If you'd like to support the Talking Law podcast, then please do feel free to get in touch. You can follow me on Twitter at SallyPenny1 and on Instagram at SJSallyPenny and on LinkedIn typing in Sally Penny MBE. There are plenty of other episodes for you to catch up on, 75 to be exact. You can listen to guests including actress Maxine Peake, Supreme Court Judge Baroness Hale, now retired, and Lord David Panic, KC. Thank you so much to our production team at Purposeful Podcasts. I'm Sally Penny, MBE. Bye for now.